On judgment, item 1, everything 4 of the page.
The decision of the second empowered committee has been set aside. It is not on relevant consideration. It is not their job to figure out whether education institution is a commercial venture or not. They are supposed to ascertain whether the application meets the requirement of the scheme document or not. So although the scheme has expired, the Commerce Ministry officials to reconsider the application and take a fresh decision in the light of observations made here. So in a way, it has been partially allowed. What will be the decision? They will communicate to the petitioner, but proper exercise has to be done. Proper application of mind has to be done. Corrections as we'll see. Corrections as in, well, not to tell them not to make it online. Like
Lordship, I beg to mention item number 28, Lordship. The matter may be adjourned for the day. As
28, 28.
Lordship, 28 and 29 is connected matter, Lordship. In item number 28, I am appearing as respondent number 6, and in 29, I am appearing for the petitioner, Lordship.
So you are for whom?
Here, petitioner, Lordship, he is out of station.
In item
28.
on the prayer of learned counsel for the petitioner in item 28 made with the consent of the other side, this matter stands adjourned for 2 weeks. List this case again along with item 29 after 2 weeks.
Lordship, there is an
Lordship,
interim
That may
protection.
be fixed if possible.
No, interim order where?
In item number 29.
Interim order passed in item, operating in item 29 shall continue until further orders.
Yes, Your Lordship. In respect of item 46, madam,
Hmm.
it's a motion matter, madam.
Hmm.
May can be taken as a motion. Contempt, madam, first time.
No, you wait, we'll see.
Well, in item 24, my lord, I am filing on IA on behalf of respondent 5.
Hmm.
There was a direction that my lord, the respondent 5 will be debarred from filing an affidavit in opposition in that case, my lord. For recalling that order, my lord, I am filing on IA today.
Hmm.
Can it be, my lord, taken up?
No, IA cannot be worked like this.
Yes, my lord, on my lord, Friday, my lord.
We'll see, let the matter be called.
Yes, at least the IA may be listed on Friday, my lord. That part, my lord. No less.
May I please this lordship? Lordship, with the consent of the opposite party, I beg to mention item number 7. Lordship, the engaged counsel is out of station. So lordship may kindly pass over the matter.
As paid for by learned counsel for the petitioner, this matter stands adjourned for a week. List accordingly. Yes.
Maybe Lordship, I beg to mention item number 8, that item can be taken up after 3 weeks, Lordship.
Your name, please.
G. Kakoti.
Mr. G. Kakoti, learned counsel for the petitioner, submits that she is required to examine certain legal issues arising in this petition, and therefore this matter be posted for motion again after 3 weeks. Prayer allowed, list accordingly.
May it please the lordship. I beg to mention item number 6, lordship.
Yes,
That I may adjourn for the day, lordship.
you are for whom?
I am for the petitioner, lordship.
On the prayer of learned counsel for the petitioner, this matter stands adjourned for a week. List
And similar prayer, lordship, regarding item number 44, lordship.
Item 44 also same prayer, petitioner. Yes.
Apply.
May it please, Lordship. I am praying for listing of an IA, Lordship. I filed it yesterday. Lordship, in a order of that SSC matter, the petitioner's name was wrongly recorded as OBC candidate, but he is a SC candidate. That correction is to be made. Obliged.
May it pleases your Lordship. Lordship, I beg to mention with regard to item number 4 of the daily list, Lordship, kindly adjourn the matter for the day, Lordship.
You are for the petitioner.
Petitioner,
On
Lordship.
the prayer of learned counsel for the petitioner, this matter stands adjourned for a week. List accordingly. Yes.
Obliged.
But one motion matter, my lord, can it be on Friday, madam? Press case. We have filed it on 16/5.
Against state or Assam?
No, union. Obliged.
May I please, Lordship, I beg to mention for listing of 2 orders matters, my lord. My lord, matters related to compensation appointment board matters.
Hmm.
The matter may be listed on next week, any date, my lord.
Why you want it to be listed?
Long back, my lord, data is not listed, my lord.
Oh, long time. There are many cases like that.
And last,
Give her a date after 2 weeks. She will put it after 2 weeks. Yes. See, if we have every case listed only on mention, then only the mentioned case will be listed. Other cases will never be listed. So they will also come for mention. And then we'll have a cause list which is 150 matters. So don't do it. Yes.
Okay, I can do it.
None appears to the petitioner on call. This matter stands adjourned for a week. What is this matter? Miss S. Sharma, Lanet, SC, Health and Family Welfare Department, Assam is
They
present.
claim for minimum wages. The petitioner claims for minimum wages from the authority, but they were
All right,
appointed
then
by.
2 weeks, 2 weeks. Sharma, sir. Lanet, Standing Council, Health and Family Welfare Department is present.
Item 3.
May I please your lordship? Lordship, in this matter, we have filed an IA for impleading some of the junior lordship. Lordship may taken up after a week, lordship. Lordship.
Mr. Your name, please?
N.K. Sharma.
Mr. N.K. Sharma, Lanet Council for the writ petitioner submits that an interlocutory application being IA number,
We have got a filing number only, Lord.
interlocutory application for implement of new respondents have been filed. Implement of new respondents in this writ petition has been filed, but the same has not been listed. As such, a prayer has been made to list this writ petition along with the ID. Mr. J.K. Goswami, Learned Additional Senior Government Advocate of Assam, is present on behalf of the state. On the request of the petitioners council, let this writ petition be listed along with the ID.
Obliged, lordship.
Item 5.
Listed again along with the ID.
May please, your lordship. My lord, here in this case, my lord, IS 1080 file, my lord, who implement the selected candidates in the writ petition.
What is this matter about?
My lord, it's matter relating to selection of selection and appointment of grade 4 post against disability candidates, my lord. Disability category. And in writ petition, we could not implement the selected candidates. Now we want to implement the selected candidates. Some of the
What is the IA number?
IA 1080/2023.
You want to implement opposite party numbers?
Opposite party number 1 to 50, my lord. At page 53, starts from page 53. 1 to 50, they may be implemented as respondent number 62, my lord, 13 to 62.
13 to 62.
Yes, my lord.
Yes, what do you have to say?
Lordship, implement.
All right, heard Mr. A.R. Sigdal and council hearing for the applicants. Also heard Mr. J.K. Goswami, learned additional senior government advocate Assam appearing for the state. By filing the connected writ petition, the applicants stroke writ petitioners have assailed the selection process leading to the selection of the leading to selection of as many as
511 candidates.
511
11 candidates.
candidates. Mr. Sigdar submits that while filing the writ petition, the selected candidates were not included as respondents in the writ petition. Hence this IA. Mr. Peruse the statements made in the IA. It is apparent that if the writ petition, if the writ petitioners will succeed in their attempt, then it may lead to disturbance of the appointments of the opposite parties in the IA. As such, the opposite party numbers 1 to 55.
My lord.
As such,
1
the
to
opposite
50,
parties numbers 1 to
50.
1 to 50 are necessary parties in the connected writ petition. Accordingly, a prayer made in the IA stands allowed. The registry to include the respondent numbers, no, the respondent numbers 1 to 50 are included in the connected writ petition as respondent opposite party numbers 1 to 50 stand included in the connected writ petition as respondent numbers 13 to 62, registry to make necessary endorsement in the cost title and thereafter list the matter for motion. Highest term disposal. It will take time. It might take 2 to 3 weeks time
My lord,
because it's a long affair.
my
We have
lord, yes,
not done it. Highest term disposal.
deep love, my lord.
May I please, Manoj? Manoj, this is against a recruitment to the post of office come field assistant in APDCO. What had happened was, Manoj, there was a selection process. Advertisement was there, we all participated. But my lord, while making the selection, women reservation was not provided for. There were litigations before this honorable court, wherein my lord, they said in an order, in a representation disposal order, that at the final stage, basing on the directions that would be passed, we will take into account that. Then there were candidates who had come up before my lord, wherein my lord, they said that we come within the zone of appointment. So kindly, this honorable court directed them to appoint. Now, my lord, there were 692 posts, and this was not declared earlier. This was declared only subsequently. 1 to 353 would be for general. So therein there is 74 women reservation, and the need is, my lord, 106. So, my lord, after 354, because in our state it's, my lord, category wise, I would be the first one at 372. But people below me now, I had appeared before them, for them also, my lord. But below me has been appointed. Even if they are appointed, I can still be appointed because around 4 or 5 appointments have been made. It has not reached that 106 level. My lord. This is my case before, my lord.
Who is appearing?
My lord, I have a query. My lord, at this stage, my lord, notice may go, my lord, next week, my lord, I will bring the record.
Then you obtain instructions.
Instructions only, my lord.
Next week, my lord.
Mr. Ukenal and senior counsel appearing for the writ petition. There is the amendments made in the writ petition. The only grievance of the petitioner is that the respondents have not implemented the reservation meant for women quota while filling up the
Post of office come field assistant.
post of office come field assistant. First up, Mr.
I, Kolita.
I, Kulita, learned counsel appearing for the respondents is for a week's time to seek instruction, preliminary instruction,
Lord.
and respond to the grievance expressed in the writ petition. Prayer allowed. One extra copy of the writ petition be furnished to Mr. Kalita. Let this writ petition be listed for motion again after a week.
Lordship, much obliged.
My lord, the matter is otherwise covered. On last occasion, lordship was pleased to direct the other side to obtain the instruction, my lord, whether it is covered.
Is it covered case?
No, though it's covered, my lord, there is an order from the writ appeal, my lord. That order, your lordship, kindly have a look on it.
We have annexed that order.
Also, they have annexed it. Because the writ appellate court refused to grant stay, but benefit restricted to the respondent of that writ appeal, my lord. And therefore, it's not general.
Then let me just.
Yes, no, that's a fact, my lord. Please come to page 71, my lord. Now, the appeal was preferred by the APDC.
But what is the matter here?
Yes, my lord, if your lordship would kindly permit me to place one page that will clarify. Please come to
Yes.
page 37.
Yes, please.
4. Application of revised pay. All employees were in service on 31st of March 2016 or who may have been appointed on or after 1st of April 2016 shall draw pay in the revised pay scale. Now, my lord, the present petitioner, as in the petitioner which is covered by the judgment you have referred, my lord, they all retired after working on 31st. So therefore, they are entitled to the revised pay scale. And Ryan single judge has ruled in that favor. Because on 31/3/2016, the present petitioner as well as the petitioner in the other case, my lord, they were in service of the corporation, my lord. So had it been a case, my lord, I would have retired on, forenoon of 31st, then things would have been different. I retired afternoon, my lord.
So, but it
But
says
that's the
who was
small
in
point.
service on 31st March.
Yes, I retired on 31st.
Then if they are in 35, where is the order, single judge?
Yes, my lord. Please come to page 69. Para 20. Last two sentence. From a conjoint reading of the provisions of revised pay rule 2017, more particularly rule 1 and 2, rule 4A, rule 31AB, together, this court is of the unhesitant view that petitioner was in service on 31/3/16 and who retired from service on reaching the age of superannuation, also on 31/3/16, cannot be categorized and bracketed in the category of existing pensioner on 31/3/16, as he acquired the status of pensioner only on and from 1/4/2016. In such view of the matter, benefit under revised pay rule cannot be worked out by resorting to rule 32(1)(a) and B of the revised pay rule, but his entitlements are to be worked out in terms of the provisions laid down in rule 4A of the revised pay. So this is the finding. Against which, my lord, APDCL has gone on appeal. And my lord, strenuous argument was advanced. Court did not, my lord. However, court said that the whatever benefit that petitioner will get, my lord, that will be subject to outcome of the appeal. Now, if your lordship may kindly come to 71. Kindly see, my lord. Respondent petitioner retired in the year 2016. Learned single judge, while accepting the writ petition, directed respondent appellant herein to extend the benefit
So
of
same condition will pass,
Yes,
dispose
yes.
of this matter.
Yes.
No problem of our copped up because of 72 last paragraph in the page.
Yes.
Last paragraph. However, we make it clear, the order being passed by this court shall be limited to the case of the respondent hearing only. Meaning thereby, my lord, the court refused to grant interim stay. And that stay only for the not granting stay benefit will be granted to him.
No, Mr. Kotoki, see,
No,
it is not about the division bench order. If you prefer an appeal in this case, then
Yeah.
the division may
Same
or may
party.
not pass same order.
Ah.
But the question is, single bench order will cover his case only.
no, my lord, single judge, yes, my lord. We were also party in the single judge, my lord. In the proceeding, earlier proceeding. Because it is the entire pay commission rule covered for 3 companies.
Kindly see,
Yes.
my lord, thus we are not inclined to stay the effect of the operation of the impugned judge.
However,
However, it is make it clear that order being passed by this court shall be limited to the case of the, because that was on that occasion, there was only one case. Court, there was the.
Here also there is one petitioner
Yes.
only. No, Mr. Kotoki, let's be clear about one thing. The learned single judge has passed a reasoned order holding that people who were on service on 31st of March were not pensioners but were employees. And therefore, the rules will apply in a particular manner. That judgment is assailed, but there is no stay order. So this court will have to follow that the ratio in that judgment. This will be binding on this court.
no, my lord, right, absolutely. I'm not disputing it, my lord. Because of that, my lord, order of the division bench, that if your lordship say that positive side is in his favor, but negative side, the other side,
No, my lord, in case if they succeed in appeal, we will be bound to return
No, my
the
lord.
benefit.
You get a similar order from the division bench. He has heard Mr. Ken Chaudhary, learned senior counsel, assisted by Miss So-and-so. Your name? please?
And Mahanta.
And Mantal and counsel for the writ petitioner. Also heard Mr. S. Pataki, learned counsel appearing, learned standing counsel, Assam Electricity Grid Corporation Limited, bracket AEGCL, appearing for all the respondents, full stop. The petitioner herein was an employee of the AEGCL and he had retired from service on attaining the date of superannuation with effect from forenoon of 31/3/2016.
Yes.
Full stop. As per the notification dated 12/12/2017 issued by the APDCL covering the cases of employees of all the 3 units, including the AEGCL, the revised pay scale would be applicable in case of those employees who were in service on 31/3/2016 or who may have been appointed on or after 1st April 2016. First of, the petitioner's case is that the petitioner's case was that he was in service on 31/3/2016 and therefore would be entitled to the benefits of the revised pay rules 2017 as notified by the OM dated 12/12/2017. First up, Mr. Chaudhary has also invited the attention of this court to the decision of the learned single judge rendered on 3/11/2022 in connection with WPC number 1607/2020, wherein a similar issue was decided by holding that the employee who was in service on 31/3/2016 would be entitled to the benefits of the revised pay rules, 2017. First up, Mr. S. Kotaki, on the other hand, submits that the judgment and order dated 3/11/2022 has been taken in an appeal before the division bench, which is pending disposal. The learned counsel has, however, fairly submitted that there is no stay order in respect of the judgment and order dated 3/11/2022. Full stop. The operative part of the judgment and order dated 3/11/2022 would be relevant in this case and therefore is extracted herein below. Para 20, page 68. Full stop. Having regard to the undisputed facts and circumstances of the case, as well as the decision rendered in the case of WPC number 1607/2020, this court is of the unhesitant opinion that the petitioner's case is covered by the said judgment of this court. Full stop. I have also perused the order dated 22/3/2023 passed by the Honorable Division Bench in WA number 107/2023, but 2023, and find that there has been no stay of operation of the judgment and order dated 3/11/2022. In view of the above, this writ petition stands disposed of by holding that this is a covered case under judgment dated so and so, passed in WPC number so and so. That's all. This APDCL notification was applicable to all means, which are the three?
Three, my lord, is indicated at page 37.
All three
Page
companies
36.
coming under the
ACB bifurcated into three
Three
companies.
companies.
all three companies created
Page 36 it is.
after bifurcation of the AACB, which includes the AAGC.
Your lordship kindly have, there in the readable minute, there is an order for giving undertaking.
Yes.
That may be also repeated.
However, since the Honorable Division Bench has no stay of, however, since the Honorable Division Bench has clarified that the employee must give an undertaking to the effect that in case of success. No, but that was an appeal. You never preferred an appeal.
No, Miller, I have not prepared an appeal, but because that stay was not granted within that condition.
Okay, the writ petition is disposed of. So you will give an undertaking for what? That you succeed in an appeal.
No, Miller, why?
Provided readable is pending.
If the in the readable, the orders will decide, is resuming. What will be the position, Miller? Therefore, you are not.
If you don't file an appeal in his case, then
No,
what
you are
happens?
not kindly protect us to that extent, Miller. Suppose, assuming because of this single judge order, you are not passing this order.
However, in view of the observations made in the order dated in the last paragraph of order dated 22/3/2023 passed by the division bench on 22/3/2023, it is made clear that the writ petitioner would give an undertaking to the effect that in the event the judgment and order dated 3/11/2022 stands set aside by a superior court, then in that event, he would be open to refund of the amount paid, excess amount paid to him on account of the present order.
Can I just come in one thing? Lordship knows if your today's Lordship's order is not appealed against, then my lord, that order is not, that's the settled law, my lord.
All right.
Supposing my lord, AEGCL does not prefer an appeal against your Lordship's order today, your Lordship's order stands.
No,
Your lordship order based on the
This
judgment.
order is based on the
Judgment
judgment.
of.
Even in those situations also, it has been said, my lord. I think it's an issue. I'm with all sense
No,
of
but
it.
in any case, if that order is set aside, then you have to refund it
Anyway,
because
but my lord, requirement of law is, my lord, they will have to file an appeal against this order also. Merely because that order is allowed does not mean the order is also set aside.
that is correct, but let
Or
Mr.
lordships can add in, my lord, rider, provided they prefer a writ appeal against this order. Then it will be appropriate.
Oh, then I'll be passing the order of the division bench. Yes.
Item 11.
May it please, my lords. My lords, I'm appearing on behalf of the Standing Council for Assam Gramin Vikas Bank. My lords, on the 10th of this month, my lords had asked me and sought for whether the documents as submitted in page 60 of the petition were furnished to the petitioner or not. I have instructions now, my lords. The letter annexed at annexure 19B was never received by the bank, my lords. Neither was letter annexure 19A, and neither was annexure 21 of the writ petition at page 68, my lords.
Then we have to
So there is-
examine the matter.
There is no question.
Lordship. Kindly look the page number 59, annexure 19A in the writ petition.
Hmm. That has been, there is a stamp. Assam
Yes,
Gramin Vikas Bank.
Yes, this is the letter to the.
Where is the original of this?
Lordship.
Where is the original of this letter?
This is the received copy, Lordship.
That's right.
My lords.
Original.
Where is the one with the stamp?
Stamp, Lordship, it was given by the office of the inquiry officer, Lordship. And it is,
Let him file an affidavit there.
Lordship.
My lords, affidavit is filed.
Where
In
is
this
it?
respect, it was filed yesterday. My lords may have my copy.
All right. Heard Mr. J.K. Goswami, learned counsel appearing for the petitioner. Also heard Mr. Debayan Banerjee, learned counsel appearing on behalf of the bank, who submits that the copies of the letters dated 17/4/2019, bracket annexure 19A, and letters dated, both letters dated 17/4/2023, bracket annexure 19A and 19B were never received by the
Lords,
bank,
Also annexure 21 at page 68. 21, lords.
as well as annexure 21 at as well as the letter dated 21/4/2023, annexure 21, bracket close, were never received by the bank. And therefore, the question of furnishing those documents to the petitioner did not arise. Mr. Banerjee submits that an affidavit on behalf of the bank stating the aforesaid facts have been filed yesterday.
16th of
Had been filed
May.
yesterday, that
Yes.
is 16/5/2023, but the same is not on record. In view of the above, registry to take the affidavit with the record of this case and list the matter for motion again on 22nd of May 2023. 22nd.
Lordship, this is difficult for me, Lordship. Kindly fix the matter after June 1st week, Lordship. Any date?
I have no objection.
June 1st week, why?
Lordship, because I will be absent in this thing.
Then we'll just issue notice.
No, Lordship, then 22, no issue, no issue. 22.
Please, my lords.
Budi paisa na, two letters saying this 17/4, one more letter 21/4. Letters dated 17/4, annexure 19A, 19B, and 21/4/2023, annexure 21 have never been received.
Obliged.
Item 12.
Lordship, kindly pass over for time being, Lordship.
Yes.
Obliged.
Item 13.
May I please your lordship? My lord, this is regarding compassionate appointment, my lord, less than 3 years, madam. SLC rejected my case, page number 17, madam.
Father died when?
Father died, my lord,
12/9/2015.
12/9/15.
And application filed on?
Application filed on 8/9/16. 8/9.
So less than 3 years, that has been set aside now.
Yes, my retable has been filed, my
Is
lord,
there a
but yet
stay
to
of,
be listed.
stay of the order? Is there a stay of the order of the?
No,
London
my
Civil
lord,
Bench?
yet
Then-
to be listed because there were defects. We were mitigating the
then
defects.
we have to hold this as covered and reconsider.
My lord,
All right, heard Mr.
FL.
Learned Counsel for the petitioner. Also heard Ms. M.D. Boral, Government Advocate Assam,
I am for 3, 5, and 6.
appearing for respondent number 3, 5, and 6. First up, Mr. N. Upadhyay,
1, 2, and 4.
Standing Counsel,
1, 2, and 4.
Irrigation Department Assam is present one on behalf of respondent numbers
1, 2, and 4.
1, 2, and 4. First up. The application submitted by the petitioner on 8/9/2016, taking appointment on compassionate ground, which was forwarded by the district level committee of Golaghat, was finally rejected by the SLC on 15/9/2021 on the ground that the father of the petitioner, that is the deceased employee, had less than 3 years of service at his disposal at the time of his death. Full stop. Aforesaid decision is based on the OM dated
1/6/2015.
1/6/2015, which has been set aside by the learned single judge by the judgment and order dated
Date, lordship, I'll give the WPC number 1646/2022.
judgment and order
Was for
dated so and
purpose-
so, passed in WPC number so and so, wherein it has been held that clause 15 of the OM dated.
Clause 1, my lord.
Huh?
Clause 1,
Clause 1 of the OM dated 15
my lord. 1/6/2015.
2015 is unconstitutional. First up, it has been pointed out that several matters have been sent back to the SLC for reconsideration after the decision of the learned single judge, setting aside the OM dated so and so. First up, Ms. Bora submits that a retable has been preferred against the judgment and order dated so and so passed by the learned single judge, but she admits that the matter has not been listed, nor is there any stay order granted by the division bench. Under the circumstances, this court has no option but to set aside the resolution dated
15/9/2021.
15/9/2021 for the petitioner and remand the matter back to the SLC for a fresh consideration in the light of the observations made herein above. The petition stands disposed of.
MDP 11.
Item 14.
May I please your lordship, my lord, it is covered by your lordship decision the other day. Same case, my lord, regarding selection and appointment of the constable. Suddenly, my lord, when new appointment, new measurement was taken, their height was found to be less, whereas last year when I appeared, my height was exactly same. Now they have to accordingly it has been reduced. So your lordship directed to prefer an appeal.
Yes, yes, lordship, there is a provision for appeal
Yes, that I have placed.
as per page 48.
Page 48.
The rejection slip itself provides lordship, there is a scope for appeal.
That's why the honorable court has passed the order, same order.
What is the appellate provision?
Lordship, this has been written that if you are not satisfied with the ground of rejection, then you may prefer in writing the appellate authority, but it says that on the same day. It says that on the same day through presiding officer.
All right, take down, heard Mr. S. Learned Counsel for the petitioner, also heard Mr. B. Chakraborty, Learned Counsel, CGC appearing for the respondents. First up, the read petitioners hearing had participated in the recruitment process for appointment of constable stroke GD in the area in the CAP, that is Central Armed Police Forces for the year 2022. According to the statements made in the writ petition, the petitioners had undergone physical standard test, bracket PST, bracket close, and the physical efficiency test, bracket PET, and emerged as successful. However, subsequent thereto, the petitioners were once again subjected to PST and thereafter declared to be unqualified on the ground of not meeting the height specification. Full stop. Contending that the writ petitioners who were earlier found to be having the requisite height would not have been subsequently declared as disqualified on such ground, since the height of the petitioners could not have reduced in a period of less than 1 year. Full stop. Mr. B. Chakraborty, learned CGC, submits that the decision of the authorities is appealable, and therefore he would have no objection if the writ petition is disposed of with a direction upon the petitioners to prefer an appeal before the appellate authority in a time-bound manner. Full stop. Mr. Chakraborty has also pointed out that similar orders have been passed by this court in similar writ petitions.
This has been pointed by my senior friend.
All right. That is not required. In view of the, Mr. Biswas also submits that he would have no objection if such an order is passed. In view of the above, this writ petition is hereby disposed of at the stage of motion hearing by providing that the petitioners may prefer appeal before the appellate authority against the rejection of their candidature. Full stop. If such appeal is preferred within a week from today, along with a certified copy of this order, the same may be considered on merit upon due verification of facts based on materials and record, and thereafter a reasoned order be passed therein, as expeditiously as possible, but not later than 30 days from the date of receipt of a certified copy of this order. Until such time, the aforesaid exercise is carried out and completed. 4 posts of five posts of constable stroke GD in the CAPF, qua the present recruitment drive, be kept vacant. The petition stands disposed of.
Item 15.
Petitioners were appointed as special police officer in their term, and since then they were working. But suddenly, both these petitioners have been withdrawn from their deployment, without giving any notice, without any hearing, and in their place, respondent number 6 and 7 has been appointed.
Lordship, I have not seen any impugn letter annexed with this petition.
Find out next week, motion. I heard Mr. J. Islam, learned counsel for the petitioner, peruse the statements made in the writ petition. Ms. M.D. Bora, learned government advocates, Assam prays for a week's time to obtain preliminary instruction responding to the allegation made in the writ petition. Prayer allow 1 extra copy of the writ petition be furnished to Ms. Bora during the course of the day. Let this writ petition be listed for motion again after a week.
My lord, deep your bless.
Item 16.
Matter is about compassionate appointment. Petition of order died in harness on 13/9/2012. And SLC rejected the proposal of the petitioner because of less than balance period of 3 years of service.
Same order will pass. Only date will ELC of Contempt for research. When did the petitioner submit application?
26/11/2012.
26/11/2012. Date of death of father 13/9/2012. Date of rejection by the SLC 13/1/2023. No, 31 to the. When was it rejected by the SLC?
10/2/2020. 10/2/2022, page 38. Relevant portion is page 38. Below part.
SLC resolution 10/2/2022. Huh? Are you at a nominee Miss Borwa, government advocate Asim?
For 1 and 4.
For one, Mr. B. Gogoi, I'm standing counsel, PWD, for respond numbers 2 and 3. Would you say I will order to do the same movie? This point. MD Bora, what are any Mukotai boy? Yes.
Yeah, I was serving in Bindukuri, Tezpur, where this matter relates to. I was serving as a state in charge of state number 4 and 5. I was charged after relieving from that branch. I was posted in Nagaon, Divisional Office of Food Corporation of India, and I was charged for major penalty by GM region on 22/7/19 for the period of which posting is head in charge from 11/4/17 to 31/10/17.
I have instructions in this matter. Petitioner was imposed penalty of recovery of 1,80,000. Against that penalty order, they have filed an appeal dated 24/2020. But the executive director office in the journal office, they are saying that they have not received this appeal because it was sent through the divisional office Nagaon. But now we are saying that we will dispose of the appeal within 60 or 90 days, my lord, taking into consideration the appeal annexed in the writ petition, my lord. So this matter may be disposed of, giving a time frame.
60 days, let them dispose of the appeal.
Yes, my lord.
All right, heard Mr. G.K. Gupta, learned counsel appearing for the writ petitioner. Also heard Mr. B.K. Singh, learned standing counsel, FCI appearing for the respondents. Aggrieved by the order of penalty dated 18/12/2019 imposed on the petitioner for recovery of a sum of rupees 1,80,000 from his salary in 12 monthly installment. The petitioner had preferred an appeal before the executive director, any zone, Guwahati, on 24/2020. But since no order has been passed in the appeal, the petitioner has been compelled to approach this court by filing the present writ petition. First up, Mr. Singh submits on instruction that the departmental authorities have not received the appeal till today. But since the memo of appeal is annexed to the writ petition, if 60 days time is granted with effect from today, the appeal will be disposed of with a reasoned order after giving an opportunity of being heard to the petitioner. Mr. Gupta, learned counsel for the petitioner, has also agreed to the said recourse. In view of the above, this writ petition stands disposed of by providing that within 60 days from today, the appeal preferred by the petitioner. Where is the memo of appeal annexure?
Memo of appeal is at page yeah, the appeal.
36.
Page 38, it starts.
36.
38, my lord. 39 is the relevant appeal.
Annexure A7. Be disposed of within a period of 60 days from today, after giving an opportunity of being heard to the petitioner. Since the respondents are already represented, no further notice in this matter would be required. Full stop. No, since both the parties are already represented in this case, no further notice will be required in the matter. Full stop. The petitioner to appear before the respondent number.
Respondent number, executive
within
director.
60 days from the date of
Respondent number-
appearance of the petitioner before the respondent number 2. The petitioner to appear before the respondent number 2 and produce a certified copy of this order within 1 week from today.
My lord may dispose of this.
With the above observation, now if the petitioner continues to remain aggrieved in the matter even thereafter, it will be open for him to approach this court once again by filing a fresh writ petition. With the above observation, this writ petition
The
stands
petitioner is required to appear before,
Yes.
within 1 week, no?
within 1 week and produce a certified copy. You appear and give a certified copy within 1 week. Then within 60 days thereafter, the appeal is to be disposed. If your client is still aggrieved, you can approach this court again. Yes.
My lord, similar case wherein 90,000 was imposed as a penalty.
So instead of 80,000, it will be 90,000. And what about the order of penalty?
Order, they have any.
Order of penalty is at page 22. 90,000 was imposed, my lord.
What is the date of the order of penalty?
28 to 2020.
28 to
Order of penalty date on 28 to 2020, amount of 90,000. Where is the appeal?
That is annexure A4 dated 4/5/2020.
23, page number 23.
So memo of appeal at annexure A4. Baki kini eke thakibo. Disposed of.
Obliged.
Obliged.
May it please Lordship. Lordship, I have challenged the transfer order, Lordship, which your Lordship will find at page number 19, annexure 5, madam. The transfer order itself explains, my lord, that this is in a punitive nature, my lord. May I read the transfer order? May I read it, my lord?
Yes.
Whereas the CDPO Narayanpur ICDS project has reported filed letter number such and such dated 4th April 2023 that the Srimati Karabi Budwa petitioner hearing Supervisor Kodunabari ICDS project while serving as supervisor under ICDS Narayanpur project allegedly directed and compelled the CDPO Narayanpur to do things as per her wish, and in many occasions she allegedly humiliated the CDPO by her actions. In one occasion, when selection process of AWD Anganwadi worker by way of promotion from Anganwadi helper, she allegedly directed the CDPO to take decision as per her will, and when denied, she not only insulted the CDPO but also knocked on his table and
So it's a
silenced him.
punitive transfer, will state. Yes. But Mr. T.R. Sharma, Learned Counsel appearing to the writ petitioner. The petitioner herein is serving as the supervisor
At Korunabari ICDS project, Lakhimpur.
at the Korunabari ICDS project, Lakhimpur. By the impugned order dated 9/5/2023, he has been transferred and posted in the Majuli ICDS project at Majuli. By referring to the impugned order, Mr. Sharma submits that the transfer order is punitive in nature and therefore unsustainable in the eye of law. After a careful reading of the order dated 9/5/2023, this court is of the opinion that the petitioner has made out a strong prima facie case in her favor, justifying an interim order.
Lordship.
Lordship, this order was passed on 9th of May, Lordship.
Hmm.
Now it is 17, Lordship.
Hmm.
Whether she was released
If she is released, we'll direct she should be restored back.
or he was joined in the new
No,
post.
even then she will. How can this kind of order be
Lordship,
passed?
Lordship,
Insubordination, etc., etc.
Lordship.
If you want to transfer it, don't mix transfer and disciplinary action. Those are two different things. Uh, it is to be borne in mind that an order of transfer would take the color of a punitive order if the same is issued so as to enforce a disciplinary measure based on allegation of misconduct, which is the case in hand. First up, under the circumstances, the impugned order dated 9/5/2023. Under the circumstances, this matter calls for examination by this court. First up, Mr. J.K. Goswami, learned Government Advocate Assam, appearing for the respondents, respond numbers.
Lordship, all the respondents. All the respondents.
Respond numbers
All the- all the
raised for some time to obtain instruction in the matter, prayer allowed. NOM 4 weeks. Since the respondents are already represented, no formal notice is required to be sent in this case. Extra copy of the writ petition be furnished to Mr. Goswami so as to enable him to obtain instruction. Hard in the prayer of interim review, having regard to the facts and circumstances of the case. The operation of the impugned order dated so and so is hereby stayed. Consequently, the petitioner shall be allowed to continue as supervisor in
Coronabari ICDS,
Coronabari ICDS project,
Lakhimpur.
Lakhimpur until further orders. Actually, in the previous part, it is to be borne in mind that that's thing that has been said, that will come first, and then you write a strong prima facie case, and then that part will come.
Obligement.
Kindly matter item 12.
May I please your lordship, my senior is laying in court number 2
Then not
for
today.
final hearing.
Can't be more than 2 passovers, not possible. Since the petitioner's counsel is not prepared to argue the matter even on the second occasion when the matter is called, this writ petition stands adjourned for the day. Ms. S. Borua, learned Government Advocate Assam, is present on behalf of the state. Let the matter be listed again for motion. What is the case? You are not ready? Why?
For admission, I think I do.
May I please your lordship? My lord, initially lordship, I have challenged the promotion of the respondent number 4 and 5 lordship. But now lordship, at this stage, I am not pressing their promotion lordship. Only lordship, I was appointed in the year 1992 lordship. Thereafter, I joined as grade 4 employee on 13/12/1994 lordship. And still then lordship, I am continuing as a grade 4 employee lordship. But there are so many vacancies in the grade 3 lordship. So my case may be considered lordship on merits lordship by the authority.
My lord, as per, I'm relying on the affidavit filed by the department, my lord. As per the affidavit, my lord, the educational qualification certificate was not annexed with the appointment of the petitioner, my lord. That's why his, and on the
I'll
last
produce it.
occasion, we have already asked
What is
for,
education? What is the promotional post? Grade 4 peon 2?
Grade 3 lordship.
Huh?
Grade 3 lordship.
grade 3
Promoted to
post.
grade 3
If
post.
he comes in the zone of consideration, consider his case, that's all, along with other
My lord,
eligible candidates.
my lord.
Heard Mr. So-and-so.
Ganesh Prabhuya.
And his Prabhuya counsel for the writ petition. I also heard Miss M. Kotoki.
MM Kotoki,
M.M. Kotoki, learned SC Agriculture Department,
no, my
Assam,
lord, dairy development,
Dairy Development Department, Assam, appearing for respond numbers.
2.
Respond number 2 and Mr.
SM Krishna for private respondent number 4 and 5.
S.N. Kristatia for private respondents 4 and 5. Mr. J.K. Goswami, learned Government Advocate Assam, has appeared for the respond numbers 1 and 3. First up, the writ petitioner hearing was appointed as a grade 4 bracket boiler Khalasi under the Assistant Dairy Development Officer Town Milk Supply Scheme, Jorhat on 13/12/1994. And thereafter, by order dated 02/05/2004, he was transferred and posted under the Superintendent, Town Milk Supply Scheme, bracket TMSS, bracket close Khanapara, Guwahati, full stop. The grievance of the petitioner is that although he has been discharging his duties with utmost sincerity and devotion, his case has not been considered for promotion to any grade 3 post till today. First up, Mr. So-and-so, learned counsel for the petitioner submits that although the petitioner had initially assigned the promotions given to respondent numbers 4 and 5 to grade 3 post, yet at this point of time, his only prayer is to consider his candidature for promotion to a grade 3 post in accordance with rules. First up, in other words, the petitioner is not assailing the promotion given to respondent numbers 4 and 5 in this writ petition. First up, Ms. Kotoki, learned counsel for the respondent number 2 submits that the petitioner's case will be considered for promotion in accordance with rules if he meets the eligibility conditions. First up, similar is the stand of Mr. Goswami, learned additional senior government advocate Assam, appearing for the state. Since the petitioner is not challenging the promotion given to the respondent numbers 4, now since the petitioner is given up his challenge to the promotion given to respondent numbers 4 and 5, it would not be necessary for this court to go into the said aspect of the matter. First up, having regard to the submission made at the bar and as agreed to by the parties, this writ petition stands disposed of by providing that the respondents may consider the case of the petitioner for promotion to grade 3 post along with other eligible candidates in accordance with the rules if the petitioner comes within the zone of consideration. If vacancies are available, it is expected that the respondents will initiate appropriate steps in the matter without any unreasonable delay. Writ petition stands closed. If vacancies in grade 3 position is available, then
Lordship, without affecting the promotion of respondent 4 and 5, it has been recorded. Lordship.
no. He has given up the challenge.
sir.
That's the end of the matter. Yes.
Obliged, Lordship.
Yes.
My lord, this matter was earlier disposed of on 3/6/2022. Subsequently, a review was filed and review was allowed, and it is now it has come for your before your lordship. The issue here in my lord, the writ petitioners applied for a selection process for the post of part-time, full-time sweepers in Allahabad Bank. Lordship may have a look at the advertisement. It says, page 14.
So today for final disposal,
My lord, your lord,
how much time will you take?
it won't take much, time, just a small.
5 minutes, 5 minutes. Otherwise, wait for the other matters to be over.
My lord,
What do you want?
if he agrees for a disposal, I do not have. any-
Your lordship, I have just come up with a brief today only because the bank has handed over me the brief today. So,
You read the brief, we'll take it up in the second half.
your lordship may kindly allow some time, just pass over the matter for the day because. As after review, it has been come up, so.
Only thing the petitioner is praying before a lordship that the result should be declared. They are not asking for anything more. It is the result they want to be declared of the selection process.
So what is the big deal here?
Your lordship,
Have you not declared the result till today?
No, my
No, your lordship, thereafter some ministries, circulars and notifications is there.
Hmm.
So by that, we have stopped to declare the results.
Hmm.
That is the only reason.
Result of what? Which exam?
Result of the interviews.
Interview for?
Interview for the
Sweepers.
post of sweeper.
part-time, full-time.
Part-time
sweepers.
sweeper.
He is out of job.
No, they have not even got that employment. my lord. It is an,
So can a mandamus be issued, declare the result?
my lord, they have initiated a selection process. Interviews were held, but they are not declaring the result.
They are entitled to.
But they should give a reason. The reason being,
He's saying separate policies have been documented.
yes, if that is the policy, that will operate prospectively, my lord.
That has been remarked in the earlier
That-
judgment also.
That, my lord, the policy will apply prospectively.
You don't have any right here, Mr.
No, my lord. I have a right for consideration for the post.
Show me one judgment, I'll allow your petition today.
If he is
Just now I'll allow you, show me one judgment, that once you participate in the interview process, it gives a right for appointment.
No, my lord. I am not for a right for appointment.
It gives you a right
For
to,
consideration and a declaration of the result. I may not get, but they should come up with very strong reason to say that we are not declaring, we are abandoning it. But the reason they are citing that in view of a circular, they have kept it in abeyance. My case is, it cannot operate prospectively. That's
they are bound to declare the result.
Yes, my lord.
You'll have to labor for that.
My lord. At least, my lord, the reason which they are citing cannot be a valid reason, because the circular which they are relying came into force after the interviews were held. Advertisement, prior to that circular, the advertisement was issued, interviews were held. Now they say that we cannot declare the result, we keep it in advance for indefinite period on this circular. Our case is that that circular does not have any retrospective effect. That circular will always be prospective. On the day on which the circular was issued, the interviews were over, the selection process by which the interviews were conducted, it was the advertisements specifically provided that the interview will be on the basis, the selection will be on the basis of interview.
So that's correct. If it is an arbitrary exercise, then fine.
Yes,
But
exactly.
if it is an error of judgment, then it's not arbitrary.
No, my lord, it is not they are relying on a circular on the.
They are wrongly relied on a circular, no?
Yes.
That is not arbitrary.
No, my lord. If the circular on which they are relying does not permit them to take such a decision, then it amounts to an irrational decision.
It will give you a reason judgment. When do you want it?
Lordship, maybe a week time, maybe.
Heard Mr. S. Chakravarti and counsel for the petition. Also heard Mr. M. Sharma and counsel for the respondent bank who submits that after the review petition was allowed, this matter has been listed for the first time, and therefore he will be granted 2 weeks time to reconstitute the brief and make submissions before this court. On the request of Mr. Sharma, this matter stands adjourned for 2 weeks. List again for admission.
A date, my lord.
Date will be after 4th week of June. After 2 weeks, fixed item.
My lord, if a date is not fixed, it will not come, my lord.
All right. List this matter again on 19th of June.
And my name may be shown for the.
By showing the name of Mr. S. Chakravarti, counsel for the petitioner in the cause. Mr. Chakravarti, if every case everybody wants a date, then what happens is we may have a cause list of 140 matters, which causes problem for the court. Therefore, randomly asking for date is causing problem for us.
My lord, if dates are not given.
Because every case is urgent. Everybody wants a date.
Whatever
The
be the
moment
date,
the
my
court
lord.
fix a
In
date,
some matter, dates are given, those matters are listed, and in matters where dates are not given, those
this
matters.
is the problem. What is the fault of people who are not asking for date? Everybody will ask for a date. That means there cannot be a listing or an adjournment or a posting without a date. In that case, every case we'll have to give a date. But then our system, we don't know on 19th how many cases are fixed. Supposing 200 cases are already fixed on 19. Then it is a problem for the judge. Then what happens
So,
is
my
it's a
lord-
problem for you. Because with 150 matters, no judge will take up cases for disposal.
So, my lord, if no date is given, then, my lord, it will be fine. Otherwise, in some matters, dates are given, and some matters, my lord.
No, but
then-
what is the solution to this? There must be a solution. What is your suggestion?
Suggestion, my lord, the bench will keep a record of the dates. And depending on the dates, vacancy position case will be posted. Otherwise, my lord, in some matters, dates are given, so it is those matters which will be
That's
continued.
correct. So matters where dates are not given, they are prejudicially affected. So that means the court has to give date in every case. What about people who are not asking for date?
And for this matter, my lord, why I am insisting for a date, this advertisement is of 2014.
No, merit is another thing.
No, my
Date
lord,
of the matter
this
is another.
advertisement is of 2014, 2022, it was disposed of, then a review was filed, a review was allowed and the matter was restored.
That's right.
And my lord, on the last occasion when the review was allowed, it was ordered to be expeditiously heard. So my lord,
No, that is fine. I'm on a slightly different point. The councils have urgency, that is understandable. So, but in some cases, dates are given, some cases not given, then it creates another kind of problem. Old matters where no date is given will keep pending. Because there is a ceiling that more than this many cases cannot be listed. So supposing 100 cases are fixed on a day, the registry cannot list more than X number of cases.
so that my suggestion is my lord, uniformity. If no dates, no date for all, dates are given, then dates to be all.
Possibly in item number 21, basically we have salience for non-considerers of the promotion to the petitioner to the post of chief conservator. In the meantime, during pendency of the writ petition, an impugn order has been issued because of the pendency of the departmental proceeding. Lordship since 2003, we have refiled a writ petition. Item 23 may be taken up, your lordship. Here we silence the impugn order.
This is which department?
Item 23,
Which department?
Forest Department. But these cases are not being led by the Forest Department because they were the earlier engaged counsel of this. There is an order of this honorable courts. Government advocate are leading to this case. Government advocate. Government advocate.
Nobody is appearing for the respondents.
If some Goswami was representing the respondent, your lordship. Notice was received on behalf of the.
Okay, you call the Forest Department Standing Council. I'm not passing expert orders.
So there is an order. Lordship, notice was issued in this case, item 23, your lordship.
We'll ask the conservator of forest to come personally. Expert order I will not pass. They will come and review and then take another several hours of the court. That I will not pass. Once the order is passed, it must stay. Not in a hurried manner, pass an order, they will not implement contempt and they will come and review. These things will not do. Call for the SC, if he says he is not appearing, we'll issue personal appearance for the conservator and say that, which order you are referring to?
Lordship, in item number 21, Lordship.
Could you give the case number, please?
The petition 101, your lordship.
All right, which is the order? So government advocate is supposed to appear. Yes.
Here in this case, lordship, the forest is the main party here, lordship. The GSM is shown, lordship.
All right. So then we are summoning the conservator.
Lordship, I will inform the council of the forest department, lordship. I will inform.
No, council says he will not appear. So the file was handed over to government advocate under order of the court.
Lordship.
Government advocate is saying he will not appear. So we'll ask the conservator forest to come personally and assist the court. They are asking for an order. How can we keep postponing the matter? Principal Chief Conservator Forest. We'll pass an order for his personal appearance, but I'm just giving him 10 minutes time.
Lordship. I will consult with the standing council.
At 12:05 we'll call up the matter.
Meet business in lordship.
That on Friday, my lord, I will come up. Let it be on next week, my lord. Or on that day, lordship will fix a date, my lord, at all.
What is the IA?
I is for recalling the order dated 13/2/23. 13/2. And the respondent number 5 was debarred from filing an affidavit in opposition because of the delay cause. 13/2. Is 11. Friday.
What is the matter about?
My lord, it's regarding promotion, my lord. My lord, juniors have been promoted, my lord. The petitioners being senior, my lord, their cases are not considered for promotion, my lord. That is the case, my lord. We have challenged the promotion of respondent number 4 and 5, my lord. And my friend appears for respondent number 5, my lord, another.
But otherwise, my lord, I am senior. My lord, that statement, my lord. In the writ petition, the statement is that, my lord, the petitioners are senior to the respondent number 4. I am 5, my lord. My serial number is 241 in the gradation list. There is, my lord, 275 and 280. They are in the record.
You are for a private respondent.
Private respondent number 5.
This is which department?
My lord, Inspector General of Police, my lord.
Home department. My lord.
Yes.
And my lord, respondent 5 is a physically disabled candidate. He was promoted in that category. Petitioners are, my lord, they are not, they do not fall under that category. So they otherwise they cannot, my lord, they don't have a locus to, my
And
lord.
what about respondent number 4?
Yes, my lord. He is junior, my
promoted
lord, case 26, my lord.
He is otherwise junior to what?
Case 26. my lord.
Is
He is otherwise junior, it seems from the gradation. He is junior.
Case 26.
you are appearing for 4 also?
No, I am appearing for 5 only.
Who is appearing for 4?
My lord, four, my lord. Some beef on.
For the comment, my lord, we have filed our affidavit. Though the petitioner placed above the respondent number 4, but respondent number 4 is the physically disabled candidate. We have filed our affidavit and stated all this, my lord. Paragraph 7.
Respondent number 4 is also a PWD candidate.
My lord.
Yes, both.
Both.
Both 4 and 5.
My lord, here, my lord, my ground is that, my lord, initially, they, while the appointment was made, my lord, these two persons, they did not have the disability. They were appointed as, my lord, OBC and STH candidate, my lord. Initial appointment. While this time, my lord, promotion for, my lord, advertised issued for promotion, my lord, they, my lord, somehow procure some document, shown themselves as a disabled. My lord, in 2019, their certificates I have, my lord, annexed, my lord. My lord, while your disability must be from the initial period, my lord. Locomotive disability, whatever their disability is, my lord. Now, they have been promoted, my lord, against the, my lord, category, they were not initially entitled. Because, my lord, OBC candidate, respondent number 5 is an OBC candidate. And she has been, my lord, promoted against SC. Now, we are the SC candidates, my lord. And my lord, respondent number 4, my lord, he is STH. He has been, my lord, considered for promotion against, my lord, SC. Lord, that cannot be done, my lord, because as per their, my lord, own guideline, my lord,
So
those
this
persons
matter
who
has to be heard, we'll have it on Friday, then we
Let the affidavit. Yes.
Yes. Heard Mr. Bikadan, my counsel for the petitioner, also heard Mr. B. Gogoi, learned counsel appearing for the respondent number 5, who submits that an IA has been filed in this case on behalf of his client, which is posted on 19/5/2023, and therefore his matter be also listed again on the same date. Mr. Ms. M.D. Bora, learned government advocate, assumes present on behalf of the official respondents. First of all, in view of the prayer made by Mr. Gogoi, let this matter be listed again again on 19/5/2023, along with IA number.
The number has not been given, well, automatically it will come, my lord. I will be clubbed with this, my lord.
By clubbing the interlocutory application
Filed by respondent number 5.
filed by the respondent number 5 with this case.
All right. All right.
May I please, Madam?
Lordship, here in this case, Lordship, the instruction not received as per the last order. Lordship. I'll fix the matter. After 2 weeks, Lordship, I will submit.
Yes, my lord, last chance, my lord.
As shall 4 weeks.
Last
Heard
chance.
Mr. B. Kumar, learned counsel for the
No,
petitioner, Also heard
It is
Mr.
22
J.K. Goswami, learned additional senior government advocate Assam, who prays for and is granted 4 weeks further time to obtain instruction and file affidavit in the matter. It is made clear that no further adjournment for filing affidavit will be granted to the respondents in this case.
Item 26.
May it please your lordship. My lord, this is a, oh.
May I please lordship? SGI RK Dev Chaudhary is engaged in court number 1 lordship. Kindly pass over the matter for timely.
What is this matter? Mr.?
My lord, actually, it's a review matter. Actually, order was passed by Honorable Justice Sarto, my lord. Now, what has happened? This person, my lord, he is overqualified. Last 33 years, he has not been given a single promotion. Now, my lord, following my, when I was not, promotion was not forthcoming, nothing was forthcoming, then I resigned. They do not accept my resignation. Then I also passed MTech, my lord. Then when I got good job in, my lord, some foreign companies, my lord. Then when I joined there by resigning from the job, they will not even accept my resignation. They will declare me as a deserter. They will arrest me from my civil employment. All sorts of things are going on. Now, what the learned single judge dealt with in this case was only one part. One of the prayer was, in certain other central government organizations, there are provisions. For example, if a diploma holder, my lord, he attains a degree, then my lord, in every service there is a provision for promotion. In Assam rules also we have, my lord. Subordinate engineer on passing AIME, All India Institute of that, which is equivalent to BTech, and they are normally appointed as or promoted as assistant engineer. So the learned single judge dealt with only one point. That we also made it clear, therefore, having regard to the rules which are in vogue in other, organizations, they should also consider framing those rules for giving us benefit. On that point, my lord.
What is the review? Review on?
Because other points were not even considered. In the writ petition, amongst others, say, my lord, 5 points were asked. Only, my lord, decision is rendered on one particular. Other 4 points were not touched. That is the ground of it.
So is that a case for review then? It
Yes,
has to be appeal.
because if I go to appellate court will say, why did you go? You go and file a review. Because, my lord, a point is not taken note of. So at least, my lord, I am entitled to
In the
consideration.
writ petition, yes, in the writ petition, what is the relief you are seeking finally?
In the writ petition, my lord, amongst others, I was expecting some promotional avenues in life in the department. Or else, in terms of my other pleadings, I should have been allowed to go resign. Or, my lord, I should have been given some other benefit. Nothing.
Mr. Dev Chaudhary is appearing.
Yes.
We'll finish up this matter. Finally, let him come.
Yes.
They have to take a stand. They can't keep him. This is.
My lord, actually, my lord,
We'll close
though
all the
there are
matters.
no materials to suggest, but my lord is very arbitrary.
These things, call him
Yes.
after. I will take it up at 2.
No problem.
Yes.
Item 27.
May I please your lordship? It's a cover case, my lord. Similar matter has already been disposed of, my lord, by this honorable court, my lord. Everything similar, my lord. All the facts and circumstances.
What is this? That Constable GD.
My lord, Constable GT, my lord.
How many petitioners?
Petitioners here in 34 petitioners, my lord, and my lord, that they are, my lord, submitting the list of 8 petitioners. And we do not have any objection, my lord, in terms of that, my lord, order.
All of them are eligible.
8 petitioners are eligible.
Which are the petitioners, 8 petitioners?
My lord petitioner, my lord, here I am my lord, giving compilations, my lord, after going. My lord,
No, you tell me, which are the petitioners? Who are eligible? 8 petitioners who are eligible.
My lord, petition number 2, petition number 3, petitioner number 7, petitioner number 20, petitioner number 23, petitioner number 26, petitioner number 27, and my lord, petitioner number 19.
Disposed of.
My lord. Obliged.
See note on here which changes.
My lord, the forest department, my lord, item number, my lord, they have come. It seems, my lord, earlier counsel of the forest department cannot appear because he appeared as a lawyer. So my learned brother
Yes.
will represent my lord.
Lordship, I discussed with the council of the forest department, Lordship. I will appear here in this case, Lordship. Can you fix the matter after 3 weeks, Lordship? I will come along with all the instructions, Lordship, whatever it may be. And
This is item 21 and 21 to 24. Mr. J.I. Gorbu, learned counsel is present on behalf of the petitioner. This Mr. J.K. Goswami, learned additional senior government advocate also in the cause list on behalf of the official respondents.
Lordship.
Item 30.
Very please, your lordship. Yes, please.
This is a very checkered history of this matter, your lordship. A long drawn case. Earlier in 2000, an advertisement for the post of constable was held and the selection continued. It went up to the Honorable Supreme Court, then has come back. Then there was a direction by this Honorable Court to reconsider. And after the reconsideration, now this petition is filed challenging the order of reconsideration at page 79. My learned friend have not filed the affidavit.
Lordship, yes,
They
Lordship.
have not filed the affidavit
Yes,
as yet. I'm just making a mention about it.
Mr. Banan, what is the prayer in the
Prayer is basically, your lordship will see, we are challenging the order at page 79 that was passed after direction from the Honorable High Court to consider the matter afresh. And this speaking order at page 79 annexure C.
No, you want a direction for appointment of members of the petitioner association?
These are the members of the petitioner association.
That can't be issued. That direction cannot be issued.
Yes, Lordship.
This was all throughout these cases. These members have continued from the beginning till today.
No,
There
what
were
I'm
various
saying is,
directions.
appointment orders
Mhm.
can be issued in favor of individuals.
Yes.
Yes.
The individuals will have to be identified.
Yes.
They have to make out a
That-
case.
That is the reason another case was, or the second matter was also, or on the last occasion, this issue has cropped up by the another bench.
And then this list was there in the other case. List has not been annexed in this case. That is why the other petition.
Here the petitioners are individuals.
Their names are there in the list. The members who are the selected members, the list is there in that.
What I am saying is, Mr. Manan, please consider this.
Yes.
This code doesn't intend to be technical,
Yes.
but there are some, law is a technical matter. Otherwise, we can send WhatsApp to the judge and judge can give the verdict in WhatsApp.
Yes.
If that day comes, I'll be the happiest. But till such time, we have to stick to the technical requirement of law.
Yes.
In a petition where members of a community, minority or whatever community,
Actually, to be honest, your
seeks an order of appointment, it will be very difficult for this court to grant.
I
that,
understand.
because I have passed several orders in this light. So what you want to do, you decide. If you want to argue, I'll hear the matter.
No, argument, at least today, it will not be possible because they have also.
What
not
happens
filed
is these orders are eventually not implemented due to technical reasons. Several contempt cases, it goes on for another. You see, in every case, you find is going round and round and round. You
This is-
find these are the reasons.
This is 22 years.
Lordship,
Another 22 years will go.
Lordship, first, we have to decide the locus standi of the petitioner here in this case, Lordship. What is the locus standi of this union, of this association?
That is precisely what I am saying, Mr.
Yes,
Goswami.
Lordship.
You
Yes,
have not
Lordship.
heard.
First, this issue should be settled. After that,
So
what is
at
it,
best,
regarding the fact.
what-
These are the teething problems which
No, I understand. I
keeps
understand.
the court from going into the meat of the matter. There can't be a mandamus that you appoint the members of the, that order will never be passed.
That
Cannot
is
be
true.
passed.
That also I
Then
agree.
what are you arguing for?
I agree. This is the reason, your lordship, on the
You
last.
file petitions in the name of persons. They have a common cause, then common cause. If they have separate causes, then individually cases will have to make. Then the judge will have to pass orders on facts of each case. And then if they don't comply with the order, there will be an issue of contempt arising. But if it is an omnibus order without any specificity, and then it goes from one table to another, one court to another, how is it helping the institution or the clients?
Even I also have the same, I also.
I hope
came
you
through
understand
this.
what I'm
Yes,
saying.
yes, I understood because
These are
earlier
service matters.
I was there in the matter in, I think, 2004, when I was a junior counsel in one of the case. This now coming back to me after a long time. So whatever it is, your lordship, at that time we got an order, then ultimately it went up. At that time, we had filed that individually. Subsequently, this particular association has come up this time. They have a list of these candidates that is not annexed in this case, which I also said on the last occasion. It is annexed in the other case. That was actually, that is the reason it has been called up. Anyway, lordship will let me take up the instructions from my.
Consider it, if it was a payment of pension or some
Not pension, it's an
ex
appointment.
gratia or something like that, then the matter is different.
Exactly.
But when it is order of appointment,
Yes.
the court will have to pass specific orders
To the individual.
saying why
Yes.
this individual is entitled to the
Yes.
appointment.
So let me take instructions in this. Lordship will
How
fix
much
it
time do
after
you want?
2 weeks. Lordship. In the meantime, if I get through something or if required, I'll file.
Mr. Buddha is holding the brief.
Well, yes, yes, yes.
Okay, you take 3 weeks then. I heard Mr. Y.S. Mannan, assisted by Mr. P. Buddha, and counsel appearing for the petitioners in this batch of petition. Also heard Mr. J.K. Goswami, learned additional senior government advocate Assam appearing for the state, who raises question of maintainability of the writ petition on the ground that no mandamus can be issued for appointing the members of an association, since the individuals have not come before this court. Responding to the above, Mr. Manan seeks 3 weeks time to obtain instruction in the matter. Prayer allowed. To complete his instruction in the matter. Prayer allowed. Register to release these matters again after 3 weeks. As you have filed.
Yes.
The learned counsel for the respondent number 8 submits that the counter affidavit filed on behalf of his client today is not on record. The other counsels are present and submit that the matter be listed again after 10 days along with the affidavit. In view of the above, register to do the needful Next week. Tag the affidavit with the record of this case and list the matter again after 10 days as fixed item.
Date may kindly be fixed, Lordship.
After 10 days as fixed item.
Lordship, we have filed our affidavit today, Lordship. I pray that the affidavit may come on record, Lordship.
My lord, I have received it just now, my lord.
Will be
So
filing.
PC the learned counsel for the petitioner submits that he has received a copy of the counter affidavit filed on behalf of the department just now and therefore be granted 2 weeks time to seek instruction in the matter. Prayer allowed. Miss Arbora, learned counsel is present on behalf of the respondent.
Obliged.
My lord,
Registered
kindly-
list this
kindly
case
fix it.
again after 2 weeks as fixed item by tagging the affidavit with the record.
Obliged.
Lord, last occasion I was asked to take instruction about the calculation. So for calculation is concerned, my lord, since the date of suspension, he was suspended in the month of February 2016. And he was reinstated in the month of September 2019. He did not join. So February 2016 to September 2019 he is entitled. And accordingly, 8,200 per month. His total entitlement is 3,60,800.
3 lakhs?
60,800. And out of that, my lord, 1,72,200 has been paid as per the order passed in IA under section 17B of the Industrial Disputes Act. There was an IA under section 17B of the Industrial Disputes Act. And accordingly, his last drawn wages 1,72,200 has been paid. So now he is entitled to 1,88,600.
1,88,000?
600.
Yes, what do you have to say?
My lord,
We'll ask them to deposit the amount, take it. Matter is over.
my lord, as per our calculation, we have submitted evidence in the court, in the learned labor court, my lord. If I may just show that.
No, what is it? You tell me.
My lord, as per our calculation, since they have not deposited the money, given the money on that day itself, we have attached an interest amount as well. So now, as on the date of the submission of the evidence, it amounts to almost, my lord, 6,13,449,
Only the interest.
along with the interest.
So let them deposit 188,600 principal
Then, my
amount.
lord, labor court may decide if interest per day because
We'll finish it off here. Why go to labor court?
1,88,000, my lord, that is entitlement. It's
Let
entitled.
them deposit the amount here. You take it. And then we'll see. Then we'll see. Maybe we can sort it out through some mediation or something. We'll see.
Because he did not join. So as he did not join, because the order of award of the labor court does not say about interest. And the High Court's order, which upheld that award, there is nothing regarding interest. So
All right.
only
In
reinstatement
terms of the
that.
order dated 12/5/2023 passed by this court, Mr. K.M. Haloi, learned counsel for the petitioner, has obtained instruction and submits that the total entitlement of the petitioner is to the tune of rupees 3,60,800, out of which a sum of rupees 1,72,200 has already been paid to him, leaving a balance amount of rupees 1,88,600 as on date. Full stop. Miss S. Das, learned counsel for the respondent number 2, on the other hand, submits that by adding the interest component to the amount payable to the petitioner, the total amount comes to rupees
6,13,449.
6,13,449.
13,449.
Full stop. Mr. Haloi, however, submits that no interest has been awarded to the petitioner by the learned labor court.
But
Be that as it may, considering the nature of controversy raised in this writ petition, this court is of the opinion that the matter can be sorted out at an early date before this court if the parties agree to certain recourse which can be followed in this matter. First of facilitating the above, the petitioner to deposit the sum of rupees 1,88,600 being the admitted dues of the respondent number 2 before this court within
2 weeks.
within 2 weeks from today in the form of a demand draft drawn in the name of the respondent number 2. Registry to list this case after the demand draft. The demand draft be deposited before the Registrar General of the High Court. Let this matter be listed after the demand draft as directed by this court is deposited by the writ petitioner for necessary orders. We'll see what happens.
Sure.
Interim order may continue.
Interim order passed earlier to continue until further orders.
Item 34.
Please. But in this case, I have sent termination letter, Lordship. I have been terminated from service, Lordship.
My lord, in this case, he's a contractual employee. Certain allegations were leveled against him regarding misappropriation of funds. A show cause notice was issued to him at page 24. He had filed his reply. He has produced all the documents and post that a termination order was passed against him. And he's challenging the termination order, stating that he has not been given a due opportunity to present his side of this case, his side of the story. He's challenging that. We have given him complete total ample of opportunity.
The termination letter, Lordship, kindly 34, page 34, Lordship. I suppose that he will file affidavit, we're going to 34, Lordship.
34.
Lordship. Second paragraph, Lordship. Whereas in this regard, a detailed report was sought from the Chief Executive Officer, Huzai Jilla Parishad, by his letter so dated 23/3/2020, to which the Chief Officer Huzai Jilla Parishad has replied and stated that the fund meant for the 4 MDs beneficiaries as stated above were not credited to bank account of the actual beneficiaries, for which they could not build this so house. In this report, it is also stated that Sri Solenda Vora is so of Muraja Gao Panchayat under Binakandi Development Block of Pujai district may be assumed to be responsible for the misappropriation fund, and that the block Volcanic Development Pujai has laws and FIR so Mudahan 18/2.
So there was an inquiry held against
Yes,
him.
Lord.
Yes, my lord.
Where is the memorandum of charge?
Yes, no inquiry report, Lordship. Nothing has been, no opportunity has been given. That is why I silence. If it has been given, Lordship, their money has been credited to their account, Lordship. They have, I have managed.
No, just a minute. Where is the inquiry report?
Yes, Lordship.
Well, the show cause notice is at page 24. After that, he is duly.
Inquiry.
That we'll have to produce, my lord. If my lord instructs, we can get it on the next date.
But you have to file affidavit. He is
We'll do that. We'll produce the records and the affidavit in that case, my lord.
You are appearing for whom?
A PNRD, my lord.
No, I'm asking about the respondent.
1, 2, 3.
Then you,
Respondents 1, 2.
we'll give you 4 weeks time to file affidavit and produce.
We'll do the.
Heard Mr. D. Mohantalane, counsel appearing for the petitioner. The order of termination dated 12/8/2022. Issued to the petitioner, termination from service dated so and so, issued to the petitioner, is under challenge in this writ petition on the ground that the respondents did not follow a fair and transparent procedure before issuing the impugned order. First of Mr.
P. Handake, my lord.
P. Handake, Learned, Standing Counsel, PNRD Department, Assam, appearing for the respondents raised for and is granted 4 weeks time to file affidavit and also produce the record facilitating disposal of the writ petition at the stage of admission hearing. Just a matter for English. Yes.
Obliged.
Item 35.
Thank you, Lord. Today it was listed as fixed item, Lordship.
PWD department is supposed to file affidavit, Lordship.
PWD.
PWD.
So they were given 4 weeks time. Where is the PWD council?
B Chaudhary, 5% down, but we got a requisition on back to other department. B Chaudhary appears.
You wait, let Mr. Who is appearing? Mr. Bhinchod? You will appear.
My name may be recorded. PWD.
Heard Mr. M.H. Ahmed, learned counsel for the petitioner. Also heard Ms. S. Burwa, learned government advocate Assam appearing for the state. Mr. H. Alia, learned counsel, prays for 2 weeks further time to obtain instruction. On his request, this matter stands adjourned for 2 weeks. Let the matter be listed again by showing the name of Mr. H. Alia, learned SCPWD in the cause list.
I am for 4 and 5.
That may be fixed also.
I am for 4 and 5.
Mrs. Burwa, 4 and 5. For 1, 2, and 3.
Lordship, yes.
1, 2, and 3.
Who is it?
4 and 5. Please, your lordship, affidavit is already sent for vetting, my lord. Instruction has already come, my lord.
Miss M.M. Kotoki, learned
Kotoki.
counsel for the respondent numbers
1 and 2.
submit that the affidavit on behalf of the department is ready and has been sent for vetting. And therefore 2 weeks time be granted for bringing the same on record.
My lord.
First up, Mr.
T. Chhetri.
T. Chetri, learned counsel for the petitioner is present. In view of the request made by the learned departmental counsel, that this matter be listed again after 3 weeks. In the
Obliged.
meantime, the affidavit be brought on record.
May it please, my lord. My lord, the matter pertains to disciplinary proceeding, which were not drawn up against me. My lord, during the pendency on the last occasion, on 15/3/2023, we had come to know that the disciplinary proceedings were initiated against us. However, we have the court had given us liberty to file an additional affidavit. My lord, kindly come to page 26 of the additional affidavit once.
Yes, please.
My lord would kindly come to paragraph number 3.
Yes.
My lord, what had happened in the case is that, my lord, we had reached the fag end of our career. When those charges were leveled against us, we were told that you come and appear in the said proceeding, you sign here, you sign there, and then the charges will be absorbed against you. You'll be discharged of your charges. In this process, we abided by the same, my lord. Then what happened, my lord? We were not given the suspension order, the inquiry report, which we should have been given, which are the principles of a disciplinary proceeding, which we should have been given as the accused. That is the case, my lord. My lord, charge sheet, then inspection of documents, approaches of the proceedings, defense assistant, nothing was provided to us. My lord, then thereafter, my lord, we had given them a representation. It annexure 1 of our additional affidavit. If my lord would kindly come to page 29 of the additional affidavit, my lord. We have informed them that proceeding is going on in this honorable court, WPC 1411 of 2023, this matter. And we had requested them to furnish our suspension order and inquiry report. My lord, just one request, my lord. It has been more than 9 years, my lord. Our pension has not been released till date, my lord.
Our means how many petitioners are there?
My lord, one. My one.
Why are you saying our?
Sorry, my lord. My.
Yes, what is this?
Your lordship, earlier I have submitted that one order copy. Thereby, the writ petitioner has already been dismissed from the service on 24/1/2014. And in regard to the pension, no application has yet been filed by the petitioners. The dismissal order is with already been submitted. Your Lord.
But why don't you file affidavit?
Oh, yes, your lordship, we will file it.
You
We
will
will
file
file-
affidavit, then we'll.
In
pass
the light of this new facts, we will file it.
I'll say nothing but just 3 weeks time to file affidavit. After that, we'll dispose of the matter.
Yes.
And you also produce the records, how the disciplinary proceeding was held.
Yes, sir.
We would like to see that.
Yes.
Mr.
PR Sorma.
P.R. Sarma, learned counsel for the petitioner is present. Mr. M. Sharma, learned counsel, has appeared for the bank. After hearing the submissions made by both the sides, this court is inclined to grant 3 weeks' time to the respondents to file affidavit, facilitating disposal of the writ petition at the stage of admission hearing. It is made clear that if no affidavit is filed within 3 weeks from today, and the records are also not produced by the departmental authority, adverse presumption will be drawn in this case, and the matter will be decided on the basis of materials already available on record. List this case as a fixed item again after 4 weeks.
Highly obliged.
May I please, Lordship? Instruction yet to receive, some more time required.
What is the matter about?
Matter is that the petitioner for lordship is working as Anganwadi helper. She wants to participate in the selection process for promotion to the post of Anganwadi worker. But what happened, my lord, in a particular village, revenue village, two ICDS projects are operating. But the guideline says that promotion should be made from the revenue village, not ICDS project. Now, the petitioner is working under a particular ICDS project. A post of Anganwadi worker is fallen vacant under the other ICDS project in the same village. She wants to participate for selection to the other post, my lord. As the guideline says, it should be from the revenue village. She is qualified for participating in the selection process, but she has been denied.
She wants time to, how much time you want?
3 weeks' time.
Heard Mr. Ayed Sekar, counsel for the petitioner, also heard Ms. S. Barua, learned government advocate Assam, who prays for and is granted 3 weeks further time to obtain instruction in the matter. Let this case be listed again after 4 weeks.
My lord, in the meantime, my lord, the interest of the petitioner will be protected, my lord.
Subject to that order is already there. Then
That is the answer.
Lordship, in this matter, we have received a parawise comment recently, Your Lordship. Since our name is not reflected, I would like to file an affidavit, Your Lordship.
heard Mr. J. Kalita, learned counsel for the petitioner, also heard Mr. R.R. Gogoi,
Yes, Lord.
learned counsel appearing for the respondent numbers. You don't know.
One, sole respondent.
Sole respondent who submits that he has received parawise comments and therefore be granted a week's time to file affidavit. Prayer allowed. Affidavit be brought on record within a week from today. Registered to list this matter again on 29 May 2000.
Obliged. Please, Your Lordship. Lord, here, as per the office, note dated 13/2/23, my lords. Notice is complete on respondent number 4, but on 2 it's awaited, my lord. This is contempt petition, my lord.
Anybody has appeared for respondent number 1?
My lord,
Nobody has appeared for respondent number 1.
for respondent 1 also, the notice has been received back as unserved, my lord.
Respondent number?
1.
There is no one by the name of Diganta Borua. Your case will never progress further. Have you written the name of the respondents correctly?
Through the internet online, man, I have checked that.
All right. What to do?
I will correct that, update that. my lord.
Heard Mr.
And Anand.
So and so land counsel for the petitioner. There is the office note, await service report on all the respondents. List matter after 3 weeks. And Anand, same order. Yes.
Obliged.
Item 42.
On the respondents.
Mayor, please, the Lord. 42.
Lordship, as per Laujima Court's order dated 22/11/2022, service in respect of respondent number 6 is complete, Lordship. Let it come for admission, Lordship. Service is complete, Lordship.
Your Lordship, on the last occasion, the government took time for filing affidavit in opposition. And today was fixed for consideration of the interim order, Your Lordship. The post in which I was working, still lying vacant, it may be filled up, Your Lordship. So some interim protection may be granted, Your Lordship. What is your prayer? Your prayer is for setting aside the impugned termination order, which has been issued without initiating any proceeding, Your Lordship, not even a show cause notice, Your Lordship. Herein the petitioner, he was working as a receptionist in a community health center, Your Lordship, on contractual basis. And there was a complaint made by one staff of this state center who was trying to remove the petitioner and to appoint of one of his relatives. The allegation was that I took a fee of ₹10 from the patient. In fact, that was as per the notification circulated. All right, I had Mr. R. Mazumdar, learned counsel appearing for the petitioner. Also had Mr. D. Upamanu, learned standing counsel, Health and Family Welfare Department, Assam, appearing on behalf of the respondent numbers
1, 3, 4, 5,
1, 3, 4, and 5.
and 7.
1, 3, 4, 5, and 7. Who is appearing for respondent number 3? NHM.
Lordship, NHM,
number
Mr.
2.
B. Gogoi, Lordship. His name may be
Mr. B. Gogoi, learned counsel is
standing counsel, NHM.
has put in appearance on behalf of the standing counsel. NHM has put in appearance on behalf of the respondent number 2. Office note indicates that service of notice on respondent number 6 is complete. As such, this matter is ready as regards service. Where is the office note?
20, there is a Laujima order, Lordship, flag mark, Lordship. It has been flag.
All right. This matter is ready as regards service. Mr. Majumdar submits that this writ petition was fixed today for consideration of prayer for interim order. Mr. Upamanu, however, prays for 4 weeks further time to obtain instruction. Full stop. The order of termination from service dated 9/8/2022. 9/8 on 2022, and it's a 7. 9/8/2022. Issued to the petitioner is under challenge in this writ petition. Mr. Majumdar submits that his client apprehends that the post held by her might be filled up by the authorities during the pendency of this writ petition. Hence the prayer for interim order. Also, taking note of the submission of Mr. Upamanu, this matter stands adjourned for 6 weeks so as to enable him to file affidavit. However, by way of an interim measure, it is provided that the post held by the petitioner shall not be filled up till the returnable on the next date.
Highly obliged.
Item 43.
Post earlier held by the petitioner shall not be filled up till the next date. None appears to be. Who is for the petitioner? None appears to the petitioner and called. Matter stands adjourned for a week. Yes.
Item 45.
Well, this is a contempt petition alleging willful violation of order.
Alleging willful violation of the order dated
At page 21,
page
11, my lord.
order dated 17/2/2023 passed by the learned single judge in WPC number 682/2023. This contempt case has been filed. I peruse the statements made in the petition. Issue notice of motion returnable in 6 weeks upon the sole respondent petitioner to take steps accordingly.
Item 46.
Had Mr. A.K. Hussain, learned counsel for the other, had Mr. J. Patwari, learned counsel. Alleging willful disobedience of the order dated 5/9/2022 passed by this court in WPC number 5718/2022. This contempt case has been filed. I peruse the statements made in the petition. Issue notice returnable in 6 weeks. Petitioner to take steps.
Item 47.
May I please, Lordships?
Also will kindly take page number 20, your lordship order.
Had Mr. D.R. Google and counsel appearing. for
My
the
lord,
petitioner alleging
I'm
willful
retiring on 20, I'm retiring in August.
uh, willful disobedience of the order dated 16/3/2023 passed by this court in WPC number 4205/2022. This contempt case is filed. Mr. Gogoi submits that his client is retiring in the month of August 2023, and therefore there is urgency in the matter. In view of the above, issue notice of motion returnable on 9th of June 2023. Petitioner to take steps for service of notice upon the respondent by registered post with AD within 3 days from today. Three days from today, take steps.
My lord,
Steps within 3 days.
my lord.
Lordship, may it pleases your lordship, order was given by this honorable court for payment of pension, my lord, to the husband of the petitioner, which was denied, your lordship. They have passed an
We are
order.
under senior counsel assisted by Ms.
M.
J. Das. J. Das, is it?
M. Chakravarti.
M. Chakravarti and counsel for the petitioner alleging willful disobedience of the order dated 9/11/2022 passed by this court in WPC number 4420/2021. This contempt case has been filed. I peruse the statements made in the petition. Issue notice returnable in 6 weeks. Petitioner to take steps for service of notice upon the respondent by registered post.
At page, my lord, 12, my lord.
Mr. A.K. Dattal and counsel for the petitioner alleging willful etc. 17/1/2023 passed in WPC number 6315/2022. Notice 6 weeks. Rest will be said.
May it please your lordship. Lordship, as per order dated 11/5/2023, service is complete, lordship.
Heard Mr. P. Borderline and counsel for the petitioner.
I am for appearing for respondent number 2 and 3.
Also heard Mr.
A.R. Borwa.
A.R. Borwa, learned counsel who has appeared for respondent numbers 2 and 3. Loajima court order dated 11/5/2023 goes to show that service of notice is complete in respect to respondent numbers 4, 5, and 6. Since the respondent number 1 is represented by the CGC, this matter can be deemed to be ready as regards service. As such, register to verify as to whether any counsel has entered appearance for the respondent numbers 4, 5, and 6, and list the matter thereafter by reflecting the name of learned counsel for the parties in the cause list, including the name of CGC for the respondent number 1
Admission, lordship.
for admission.
Oblige, your lordship.
May it please your lordship. My lord, considering some urgency in the matter, in a pending writ petition, we have filed this IA matter. Now, if your lordship would kindly take the writ petition, I'll just take 5 minutes time, my lord. Please come to the writ petition, my lord. To place the rule, my
Who's for
lord.
the other side? Who's for the other side?
We have served copy everything.
Revenue and personal matters, there are served copies, madam. Name is also shown in the copies.
Mati diya. My lord will kindly come to page number 52 of the writ petition, my lord. Precisely page 51, annexure B. These rules may be called Assam Land and Revenue Service Rule 2015. Now, my lord will kindly come to 2Z. Member means a member of the Assam Land and Revenue Service. 2I, service means Assam Land Revenue Service. Then my lord will kindly come to the next page. Rule 3 on top, class and cadre. 3.1, service shall consist of the following. I'll have your lordship's attention to C. Junior grade, it shall include the cadre of circle officer. So circle officer is a post, my lord, which is comprised in junior cadre of this particular service. A member of a service in different cadres shall hold post as shown in schedule 1. Schedule 1 is at page 60, my lord. Page 60, a list of post equivalent to and include in the cadre of the service, junior grade circle officer. One cadre, and my lord will kindly come to schedule 2, junior grade category of posts, then number of posts 154. That means, while in Assam there are 154 circles. So as many number of posts has been included in this service. Now, my lord, with lordship will kindly take note. This rule was notified on 2nd of July 2015 at page 51. Now, my lord will kindly come to the Assam Civil Service rules at page 82. These rules may be called Assam Civil Service Rule 1998. Then please come to 2G. Member means a member.
So what is the issue, Mr. Chaudhary?
Issue is, my lord, we are supposed to hold the cadre post. Now, what they are doing, my lord, we are being appointed as CEO attached, which is a cadre post under the Assam Civil Service Rule. And having regard to the fact that it is post of CEO attached is also included in the Assam Civil Service Rule. Assam Civil Service Rule was amended in my lord 22, wherein it is clarified at page 113. If your lordship will kindly see. Now, before that, just to appreciate, my lord, kindly come to the schedule of this Assam Civil Service Rule at page number 111, my lord. 111, huh? Sorry, huh? Schedule 2. Sorry, my lord, 98, page number 98. Schedule. Junior cadre post at serial number 8, circle officer, assistant settlement officer, under the Assam Civil Service Rule. Then, my lord, 10, circle officer attached. Now, circle officer and assistant settlement officer and circle officer attached, these are the posts also included in the Assam Civil Service. Naturally, my lord, this other rule came in 2015. So before that, it was there. Then, my lord, there was an amendment made in Rule 22. If your lordship would kindly come to 113, my lord.
Yes.
Kindly see amendment of Rule 22. In the principal rule in Rule 22, following new sub-rule shall be inserted, namely, on successful completion of probation, all ACS officers shall be considered for posting in the rank of Under Secretary to the Government of Assam, including post of SDO Hodor and SDO Civil, provided that such posting shall come into effect only after Assam Land and Revenue Service comes into force and all revenue circles are manned by officers of the said service. So, my lord, initially, when this rule was not there until July 2015, circle officer is a post which comprised in the, my lord, Assam Civil Service Rule 1998. At that point of time, an ACS junior grade officer is being appointed as circle officer or circle of attached is okay. But after coming into force of the, my lord, 2015 rules, correspondingly, my lord, this amendment was also made. Where is the scope? Now, my lord, that issue is pending before your lordships. Now, what there were 3 advertisements, my lord. In spite of the advertisements were under the coming into force of the new rules, we are still being appointed as circle officer attached. But that means we are appointed outside the cadre. Now, if you are appointing me outside the cadre, then my permission is a sine qua non. It amounts to deputation. There cannot be any deputation without the consent of the incumbent. Now, my lord, what happened during the pendency of the case? Now, if your lordship should kindly come to the IA, my lord.
What is the challenge in the writ petition?
Challenge in the writ petition, we are seeking a declaration amongst others that since we belong to the Assam Land and Revenue Service, there we alone are entitled to hold the post of circle officer, not the ACS officer. As far as ACS officers are concerned, they are entitled to be posted as, my lord, either extra assistant commissioner, either under secretary, SDO Hodor or SDO Civil. And it's a specialized cadre, my lord, Land Revenue Service.
But Mr. Chaudhary,
Yes.
these matters, the court will examine if there is a
My
violation.
lord, matter is already fixed for hearing. It's already in the hearing. Now, my lord, during the pendency of this proceeding, the government has come up with a list of additional 47 officers who are now sought to be appointed as circle officer, ACS officers. So all that I am praying for is, my lord, till the hearing takes place, these orders should not be given effect to. Otherwise, my lord, serious prejudice will be caused. Again, the proceeding will be delayed. We'll have to make them parties. And as of that, nobody has joined. It will take some time.
No, this is about a posting only, attachment or whatever is a posting.
No, my lord, Lordship will kindly consider. I'll just place one judgment, my lord, that will clarify our right. 2013 3 SCC. One small paragraph. 2013 3 SCC 526. This one.
How many more matters are there?
The page given color. 526. 526. My lord will kindly come to para 24 at page number 538, placitum D, my lord. Sentence started with broadly. At
So,
page,
Mr. Chaudhary,
yes,
just two clarificatory questions. Did you not pray for an interim order in the writ petition?
yes,
Was it granted?
the order was, my lord, the court hopes and trusts that they will appoint service cadre people in the cadre post. That was the interim order. My lord, what had happened. We are not on that. We are not seeking any stay of undo what had happened already. All that we are trying to say is during the pendency of the proceeding, how come you are appointing, my lord, 47 ACS officers to our cadre post?
No, this issue will be relevant.
Yes.
Because you are filing an IA in a pending writ petition.
Yes. Not to unsettle what had already happened, but all that we are saying is please don't create any third party right anymore. Because Lordship is hearing the matter. Lordship will hear the matter after 10 days, maybe or subject to your convenience. But till then, my lord, these orders should not be given effect. Otherwise, my lord, there will be multiplicity of proceedings, third party, and prima facie, I think we have been able to make out.
What is the order? Let's just see which is the order.
In the IA, we have annexed that order. Page 35. Lordship will kindly come to page 36, first subpara. By filing this writ petition under Article 226 of the Constitution of India, petitioner number 1 association whose members are officers belonging to Assam Land and Revenue Service has raised grievance that although there are two different sets of rules being Assam Land and Revenue Service Rule 2015 and Assam Civil Service Rule 1960 as amended by the Assam Civil Service Amended Rule 2015, the state is attempting to fill up 154 number of posts of circle officers from the Assam Civil Service Junior Grade, though such post is earmarked for members of the ALRS. Accordingly, it is submitted that as per ALRS rule, only after 154 posts are filled up by members, remaining posts could be filled up by the Assam Civil Service Junior Grade officers. Referring to the appointment order dated 9/1/19, it is submitted that members of ALRS are posted as circle officer attached, which according to Learned Senior Counsel for the petitioner is earmarked for Assam Civil Service Junior Grade. Additionally, accordingly, it is submitted that members of the petitioner association are being deprived to hold the post which are indicated in Schedule 1 of the Assam Land and Revenue Service Rule 2015. Accordingly, in respect of the prayer for interim relief, it is submitted that this is a fit case to direct the state that henceforth, if any appointment contemplated by rule in the post of circle officer, such appointment would be made as per provisions of Rule 3.2 read with Schedule 1 of the Assam Land and Revenue Service Rule. The learned so-and-so. The learned in the last parameter, sine for the petitioner has referred to order dated passed by Supreme Court in so-and-so in the proceedings suo moto in order to expedite the service of the private respondent number so-and-so. It is submitted that petitioner has been granted so-and-so. Last parameter. We hope and trust that till the next date of hearing, that is so-and-so, state respondent while filling up the post of circle officer shall act in accordance with Schedule 1 of Assam Land and Revenue Service Rule so-and-so, as amended by the Assam Civil Service Amended Rule 2015. So, my lord, what had happened, we are not that.
All right, now your clients are already working as circle officers.
No, we are attached. Few of them, but mostly we are circle officer attached, which is a post not born in the cadre of the rules. It is an ex-cadre post as far as we are concerned. My lord, we have been selected, kindly see the advertisements, my lord. Advertisement is for that particular service, land and revenue service.
That's all right, Mr. Chaudhary.
Yes.
The matter can be posted for expeditious hearing.
Yes.
But an interim order looks very difficult. You can argue whatever points you have.
No, my lord, my lord, it's not that I have to argue any elaborate thing. This is my argument. In substance, my argument is, my lord, number one, I have a right to be considered for appointment against the service against which I am recruited.
But another thing is, which is what this court has flagged time and again, and therefore we can't make an exception here. The association has come for an order pertaining to individual rights, saying that I have a right to be protected here. The applicant,
No, there are other petitioners also there, man, apart from the association.
Petitioner number 2.
who is the applicant here? Whose services, whose condition of service is being affected here?
The members of the Assam Land and Revenue Service. Number one is a registered post of my association, my lord. The petitioner number one is a registered association and it can maintain a petition. My only submission is, my lord, at least lordship will fix the matter for expeditious disposal. Until then, status.
Which is the order you are challenging?
Yes, yes. Kindly come to the IM. Page 39. In the interest of public service, the following ACS officers are placed at the disposal of Revenue and Disaster Management Department for posting them as circle officers. They belong to a different service. They are governed by different service rule. What is the question of they being appointed against our post, my lord?
No, but how does it affect you immediately? You are continuing as circle officer.
No, we are circle officer at, no, my lord. No, sir, maybe I am not being able to clear myself, my lord. Though we are appointed under that service rule, which was framed in 2015, but we are appointed against a cadre post of ACS, that is circle officer attached, is a post which is comprised in the Assam Civil Service, not in the Revenue Service. My lord, in fact, about 80 to 85% of the members of Assam and Revenue Service, they are holding the post of circle officer attached, which is a cadre post under the Assam Civil Service rule. That's what I have shown, my lord. Serial number 8 and 11 at page 92. Just I'll place that one small paragraph from the judgment that will clarify the position. Para 24, please come to placidum D, my lord. The sentence starting with broadly, has your lordship noted? Page para 24. Instead of reading the whole paragraph, I will relevant.
Yes.
Broadly, an employee can only be posted or transferred to a post against which he is selected. This should ensure his stationing while within the cadre of post under the principal employer. His posting may, however, be regulated differently by statutory rule governing his condition of service. In the absence of any such rule, an employee cannot be posted beyond the cadre to which he is selected without his willingness or readiness. Therefore, an employee's posting to a department other than the one to which is appointed against his will would be impermissible.
So therefore, if
Yes.
I've understood it correctly,
Yes,
you are saying that this, by the notification dated 29/4/2023,
yes.
these people
Ah,
who belong to the ACS
yes.
cadre,
Ah.
they are being posted as circle officer
Which is the cadre post in our service.
Yes, without their consent.
No, what I'm, from their perspective, I'm not saying that their consent, my lord. When we use the consent, it is from our perspective. What we say, I've been selected for appointment to a cadre post under the revenue service. Now, and only post to which I can be appointed is circle officer, to which now they are sought to be appointed. Now, instead of appointing us, revenue service people, as a circle officer, if I am to be appointed as circle officer attached, which is a post under the civil service, my consent is required. Without that consent, I have already been appointed. So that's why I'm saying, my lord, whatever had happened and happened, eventually, whatever.
So the government should have asked you, can we post this officer as circle
Of
officer?
course, that's the law, my lord. My lord, our simple case is, we are not asking for anything else, my lord. We have been recruited against a particular post, which is governed by a particular service rule, and we're only asking for that. We're not asking for anything else. Now, where is the question of the revenue service officer whose rightful due is a circle officer post being appointed as a circle officer attached, which is not our cadre post. It's beyond our, it's an ex-cadre post for us. And my lord, in ACS junior grade, there are hundreds and hundreds of posts. My lord, to be honest, my lord, these are all, anyway, my lord, we cannot substantiate, so no point saying, we are basically on our legal rights, my lord. My legal right is, I have been recruited against a particular service. I have a right to be a part of a particular cadre. That should be enforced by this honorable court. So all that I am saying is, my lord, this order should not be given effect to until your lordship decides the matter. What had happened, that lordship will take care at the time of final hearing. There are 154 posts in our cadre. So as far as 154 posts are concerned, we have a right to be appointed against them.
That's right, I understood. But immediately, nothing is happening to your
So
client
that's why
immediately.
status quo is on today be maintained, madam, till the matter is heard.
Yes.
My lord, in the petition, we have filed our affidavit. Lordship. In the paragraph 6, my lord, we have clearly stated, my lord, that for the probation period, my lord, they have been attached as a circle officer. Lordship, my lord, kindly see our affidavit filed by the respondent number 2 in paragraph 6. And my lord, in the 2022, some of the persons who, my lord, the vacant post, they have already been, my lord, appointed as a circle officer. Lordship, may kindly see this order. And when the vacancy was added, my lord, accordingly, the seniority was, my lord, that they have been posted. My lord, they have to, my lord, first they have to pass the training, lordship. After that, my lord, training pass, lordship, they will, my lord.
What do you say about the IA? You don't want to file objection?
Lordship, I have to file objection, my lord. What is the present status of this case, my lord? I have to file in, my lord, that reply of this.
But he is expressing urgency in the matter. How long
Lordship,
will-
I will, Lordship, may kindly grant them 10 days time. In the meantime, I will file on a reply, my affidavit.
No, I have.
In the, my lord, that I petition.
Let them file, my lord, we are not objecting to the only thing is lordship will protect our right till then, my lord. Otherwise, my lord, again, third party right will be created.
Mr. Chaudhary, I'm not convinced that this is a fit case to pass an interim order. If you want, I can pass an elaborate order. But I want them to first come with the objection and
No, my
then
lord,
see.
what I'm saying is, let them file, I'm not objecting to that. Till then, at least lordship will protect us. Till then, status quo is on today, my lord. See, first of all, this officer will have to be released. He'll be placed at the disposal of the revenue department. Then posting orders will be.
Then file your objection by
Lordship, my lord,
next
that
Friday.
Lordship, my
By 26th, you file your objection.
Until then, status quo.
We'll put the matter on 29th.
29th.
Yes.
Lordship, my lord, kindly see the IFB, Annexure B, lordship. This has been my lord, forwarded to the revenue department. And the revenue department, how many, my lord, that LRS has been, my lord, posted as a circle officer. That instruction I have to obtain, my lord.
You obtained it, that's,
My lord, I may just indicate, none of the members of the petitioner association are in provision, number one. And number two, in fact, to hold that provision post, we have the right, nobody else. To be appointed on provision, it's the revenue service officers alone has the right. But fact of the matter is, none of us is in provision.
In the 2022,
All are
lordship, my lord,
confirmed.
that instruction, my lord, I have given, my lord.
Acha, you file your objection by 24th, we'll take up the matter on 26th. Until then, don't do anything. I'll not pass any order, but tell your clients. Heard Mr. K. N. Chaudhary, Learned Senior Counsel listed by Mr. Monto, P. Monto, Learned Counsel for the applicant. Also heard Mr. J. Handy, Learned SC, Revenue Department, Assam, as well as Mr. D. Nath, Learned Additional Senior Government Advocate, Assam, appearing for the official respondents. Considering the prayer made in the IA, the Learned Department Council have prayed for time till 24/5/2023 to file objection prayer allowed. However, in view of the urgency expressed in this IA, the matter is directed to be posted again on 26th of May 2023 as a fixed item by tagging the objection, if any, filed by the departmental authorities.
And at least they will not release the officers, my lord.
Mr. Chaudhary, as I've said, you have made your point, but if you want at this stage,
My lord, only
I
till
don't
then,
want to-
till 26, in any case, they may not, only till then, they will not release the officers. Only that much, my lord.
still serving the.
They are still serving in their earlier post.
All right, you file your objection by 19th and we are taking up the matter on 22nd. Till then, status quo.
Okay.
File it. Objection be filed within 19th of. List the matter again on 22/5/2023 as a fixed matter. Till the next date fixed, status quo as on today shall be maintained.
Deep your lane.
19 lots is a Friday.
But we will be allowed to file the affidavit by Monday, Malam. Day 17th. Malam.
Today is 17.
And 24th, list the matter on 24th.
Lordship.
Deep status quo. Yes. Which is the matter fixed at 2?
There's one matter. I'll come, my lord, 2 o'clock.
What is the matter? Let us see.
Yes, let's do the matter too.
Just one case.
Oh, that's review matter, my lord. Or lordship wants to have it on any other day.
Have it list this matter again on Friday by reflecting the name of Mr. R.K. D. Chaudhary, Learned DSVI. For the respondents in the cause list.
Deep